I'm withdrawing it.
ಏನಾಯ್ತು?
Withdraw ಮಾಡ್ತಾ ಇದ್ದೀನಿ.
Withdraw ಮಾಡ್ತೀನಿ.
I have no option.
Because crime
Yes,
ಆಗಿದೆ.
yes.
97, Land Counsel for the petitioner seeks leave of this court to withdraw the petition and avail of such to that effect.
मैंने बोला था कॉल करते हैं.
ಎಷ್ಟಿದೆ? 9 ಹೌದು ಮೇಡಮ್. 13th.
Matter pertains to principal bench, serial number 1, Praveen Kamath.
For the respondents. ಅಲ್ಲಿ ಯಾರಿದ್ದಾರೆ ಕೊಲಿಗೆ ಹ್ಯಾಂಡ್ ಓವರ್ ಮಾಡಿದ್ದಾರೆ ಮನೇಲಿ Lord, there is one very recent judgment of the Honorable Supreme Court, Lord, which we have filed. Lord, in the case of enforcement directors versus Villeli Khamo, it must have been in your Lordship's file. A very short judgment on why a challenge to the summons by the ED should not be interfered with.
You have it? Senior, you have matter. So ಇದೇ matter, sir? All three of you?
Yes, sir.
Memo of appearance. File ಮಾಡಿದ್ದೀರಾ sir? Kamath sir.
Lord, I'll just clarify.
Objections are filed.
No, I have not yet filed objections.
ಇದ್ಯಾವ್ದು?
Not filed the objections.
Dr. Natesh ಇದ್ಯಾವ್ದು?
ಅದು ಹಳೆ
That is,
ಕೊಟ್ಟಿದ್ದೀರಾ ಇದಕ್ಕೆ?
well, that is the
Judgment,
which the coordinate bench of this honorable court would pass in relation to a notice that was issued by the ED under section 50 pertaining to this very crime itself against a person who is not named as an accused in the affair, just like me.
Yes.
There, my lord, his lordship would even go to the extent of saying, you file a complaint against these ED officials, take action against them.
Where is the order? Judgment. Judgment ಇಲ್ಲ ಇಲ್ಲಿ. ಯಾವ್ದು statement of objections ಕೊಟ್ಟಿದ್ದೀರಾ?
That is good, sir. ನನ್ನ ಹತ್ರ ನಾನು ಮಾರ್ಕ್ ಮಾಡಿದ್ದೀನಿ. ನನ್ನ ಹತ್ರ ಇದೆ, ಬಟ್ ಮಾರ್ಕ್ ಮಾಡಿದ್ದೀನಿ. ಅದಕ್ಕೋಸ್ಕರ ಬೇಡ ಅಂತ. Doesn't matter. Kindly ignore the.
We'll give the whole set, my lords, it becomes easy.
No, kindly ignore the markings.
It's all right.
ಅಲ್ಲ, ಅಷ್ಟೊಂದು ತಪ್ಪದ್ ಬೇಡ.
Stood judgment.
ಅದೇ ಹೇಳಿದೆ ಬೇಡ ಅಂತ. ಅದು ವಿಜಯ್ ಮದನ್ ಲಾಲ್ ಇಷ್ಟ ದಪ್ಪ ಇದೆ ಅದು.
That Vijay Madan Lal actually takes bulk.
Coordinate bench ಇಷ್ಟು ದೊಡ್ಡದು.
ಇಲ್ಲ. My lords, the coordinate bench judgment runs to 53 pages only, my lords. ಅದನ್ನ ಹೇಳ್ತೀರಾ sir? Explain ಮಾಡ್ಬೇಕು. My lords, could I just point out 4 aspects, my lords,
Now
in this?
senior is
appearing in the first matter, my lords.
I'll hear that.
129.
ಸಂಬಂಧನೇ ಇಲ್ಲ.
Then I'll hear senior first.
ಅಲ್ಲ, ನಮ್ಗೆ ಕ್ರೈಮು ಇಲ್ಲ, ಪ್ರೊಸೀಡ್ಸ್ ಆಫ್ ಕ್ರೈಮು ಇಲ್ಲ, ಏನೂ ಇಲ್ಲ.
ಅಲ್ಲ, ನೀವು ಚಾಲೆಂಜ್ ಮಾಡಿರೋದೇನು?
50, section 50 notice. Summons. My lord, your lordship, I recall to your lordship's memory when my lord heard us and granted us the benefit of an interim order.
Because I was hearing that matter, I have granted.
Yes. My lord, my learned friend, Mr. Arvind Kamath, submitted to your lordship that under section 50 of the act, I need not necessarily be an accused who could be summoned and whose statement could be recorded or whose evidence could be taken and recorded in the case.
Yes.
When I invited my lord's kind attention that I am not labeled as an offender in the predicate offense, that is the crime number 12 of 2024. But when I made that submission, my learned friend submitted to your lordship that under section 50, he could record the statement of anybody. Undoubtedly, my lord, they have the powers. May I just request your lordship to kindly turn to one of the document which I have produced at ink page 32, which is an annexure to the notice issued under section 50. In my petition, 1121.
1129.
1121.
21.
1129. Namda.
29, correct.
I'm sorry.
Yeah,
I'm
correct.
sorry. I stand myself corrected.
Yes, sir.
Can you go to page 32, my lord, for a second?
I'm there.
I can understand these things, personal profile, for a
Can
witness, my
understand.
lord, identification marks and all that, website address, telephone, residential, business.
Pro
passport
forma
number.
ಇದೆ ಇಲ್ಲಿ.
ಹಾ.
32 ಅಲ್ಲಿ pro forma ಇದೆ.
ಹೌದು,
General information.
ಜನರಲ್
question.
ಇನ್ಫಾರ್ಮೇಶನ್ ಕ್ವಶನ್ ಇಯರ್
ಹ್ಮ್.
ಅದನ್ನೇ ಕೊಟ್ಟಿರೋದು ಅವ್ರು ನನಗೆ. ಇದಕ್ಕೆಲ್ಲ ಉತ್ತರ ಹೇಳು ಅಂತ ಅಂದ್ಬಿಟ್ಟು ಅಂತ
ಓ, ಉತ್ತರ ಹೇಳಕ್ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಉತ್ತರ ಹೇಳು ಅಂತ ಅಂದ್ಬಿಟ್ಟು ಅಂತ ಏನಂದ್ರೆ ನಮ್ದು
Passport details.
ನಮ್ಮ ಅಪ್ಪಂದು ನಮ್ಮ ಅಮ್ಮಂದು ನೋ ಇಟ್ ನಾಟ್ ಸ್ಟಾಪ್ ದೇರ್. ಮೈ ಫಾದರ್, ಮೈ ಮದರ್, ಮೈ ಗ್ರ್ಯಾಂಡ್ ಫಾದರ್, ಮೈ ಗ್ರೇಟ್ ಗ್ರ್ಯಾಂಡ್ ಫಾದರ್, ಮೈ ಚಿಲ್ಡ್ರನ್, ಮೈ ಗ್ರ್ಯಾಂಡ್ ಚಿಲ್ಡ್ರನ್, ಮೈ ರಿಲೇಷನ್ಸ್. ವೈ ಆರ್ ದೇ ನಾಟ್ ಮೇಕಿಂಗ್ ಎನ್ ಇಂಟ್ರೋಡ್ ಇನ್ ಟು ಮೈ ಪ್ರೈವಸಿ ಮೆಲಾಟ್?
Brother in law, sister in law,
ಎಲ್ಲ
brothers in law.
ಎಲ್ಲರೂ ಇದ್ದಾರೆ. ಅವ್ರ ಬ್ಯಾಂಕ್ ಅಕೌಂಟ್, ಅವ್ರ ಡೀಟೇಲ್ಸ್, ಮೈ ಅಸೋಸಿಯೇಟ್ಸ್, ಮೈ ಬಿಸಿನೆಸ್ ಎಸ್ಟಾಬ್ಲಿಷ್ಮೆಂಟ್ಸ್. Will it be in or in relation to the crime which they are investigating? But I assume office as a minister during the middle of June 2023. Well, it relate to the illegal or unauthorized allotment of 14 sites. I had nothing to do with.
You are what minister?
No, Mela, presently, I am a minister for urban development and urban water and drainage board. I assumed office in June, middle of June 2023. I think I need not submit to your lordship the facts of the case because your lordship
That I
is.
know.
Yes. The proceeds of crime, the proceeds of crime, my lord, is in or in relation to the illegal or unauthorized allotment of 14 sites, excepting that nothing else. Nane. In what way I am connected with that? But even the MD, Natesh, who is said to have been the person who has actually did this allotment, a notice came to be issued to him, and dishonorable court would quash the notice issued to him under section 50 while permitting him to initiate action against the officials of enforcement directorate.
Where is that order?
Yes, my lord, may I request your lordship to kindly turn to
In the compilation that has been given, the first judgment, my lords, in that compilation.
Internal page, judgment page.
Ah. This was also against an accused?
I'm sorry, my lord.
This was against?
No, he was not, like me, my lord, he was not even an accused, but he held the office as the managing director during the relevant period. I never held any such office in Muda. Well, I come into picture to this department for the first time in my life, only during June 2023, and not earlier to that date. That is not in dispute. If that is in dispute, my lord, I can certainly place before your lordship on record the oath of office I took on being administered to me by the governor, His Excellency, the Governor of Karnataka in June 2023. What did I do? Let them come out. I have absolutely nothing to do with this. Have a look at the questionnaire. It certainly makes an inroad into my privacy. I may not protect it under the Constitution, my lord.
No, is this questionnaire not considered by the apex court in Vijay Madan Lal Chaudhary?
No, my lord. For the first
This
time,
kind
my
of a
lord,
questionnaire?
no,
Questionnaire, no, my
for the first time, my lord, they are doing all these things.
ಅಲ್ಲ ಫಾರ್ಮ್ಯಾಟ್ ಫಸ್ಟ್ ಟೈಮ್ ಈ ತರ ಬಂದ
ಹೌದೌದು.
ಇಲ್ಲ ಅವ್ರ ಫಾರ್ಮ್ಯಾಟ್
ಇಲ್ಲ, ಅಲ್ಲಿ ಇರ್ಲಿಲ್ಲ,
ಫಾರ್ಮ್ಯಾಟ್
ಅವಾಗ
ಇದೇ
ಇರ್ಲಿಲ್ಲ.
ತರನೇ ಇಲ್ಲ
ಇಲ್ಲ, ಅವಾಗ ಇರ್ಲಿಲ್ಲ.
ಈಗಿರೋದು
ಈಗ
ಆಲ್ ರೈಟ್ ಎಸ್
ನಂದಿಷ್ಟೇ, ನಂದೇನಾದ್ರು ಪಾತ್ರ ಇದ್ರೆ ಹೇಳಿ. My lord, I think it will be useful for me to invite my lord's kind attention before my learned friend Mr. Sandesh makes his submissions, because he was the one who argued this matter before the coordinate bench.
ವಿಚ್ ಒನ್ ನಟೇಶ್ ಅಲ್ಲ
Yes.
ರೈಸ್ ಆಲ್ ರೈಟ್
ಅರವಿಂದ್ ಕಾಮತ್ ಅವರೇ ಮಾಡಿದ್ರು ಅಲ್ಲಿ ಎನ್ಫೋರ್ಸ್ಮೆಂಟ್ ಡೈರೆಕ್ಟರ್.
ಅದು ಹೇಳಿದ್ರು ಅವರು
ಅಂಡ್
accepted that day when granting an entry order, yes, there is an order against us.
ಹೌದು, ಹೌದು, ಇದರಲ್ಲಿ ಬರೀತಾರೆ ಇದರಲ್ಲಿ. May I request your lordship to kindly have a cursory look at, kindly go to page 35, my lord, for a second. As far as I am concerned, I am only confining my submissions to the petition.
Only as far as you are concerned.
1129. Though on certain important and serious legal issues, I am sailing with my learned friend, Mr. Sandesh. Have a look at paragraph 25, my lord, for a second.
25.
My lord, in that spiral binding, my lord, your lordship has.
Spiral bind only, page 35, my lords. That is judgment, page 35, paragraph 25.
His lordship would refer to almost all the judgments on the point in issue.
Para?
25.
Para 25, internal page 35 of the judgment. His lordship would refer to the entire gamut of the case law on the point till 2024. Para 25, my lord. Similarly, in the present case, the alleged predicate offence pertains to the illegal allotment of sites during the petitioner's tenure as the commissioner of MODA. But I'm sure your lordship would certainly agree with me. If my lord is persuaded to accept my submission, that I am placed in a better position. Because I assume office only during June 2023, certainly not earlier to that date. However, there is no evidence to demonstrate that any consideration passed in relation to the conveyance or relinquishment of such sites was received by the petitioner. Consequently, the petitioner cannot be attributed any role in possessing, concealing, or using the proceeds of crime to constitute an offence under section 3 of the PMLA 2002. Furthermore, mere possession of a site that was allegedly illegally allotted to an accused in connection with a scheduled offence does not by itself constitute an offence under the Prevention of Money Laundering 2002, unless the essential ingredients of the offence as defined under section 3 of the Act are satisfied. In the light of the above precedents, it can be concluded that the existence of reason to believe as required under the Prevention of Money Laundering Act 2002 mandates the presence of sufficient cause to indicate the commission of the offence of money laundering. Additionally, it necessitates a corresponding justification for the seizure. That was in relation to that particular petitioner. Seizure of any records or proceeds of crime discovered during the search. Such a requirement ensures that the said property is not disappeared, layered, or integrated in a manner that renders it seemingly legitimate. To satisfy this threshold, the authorized officer must demonstrate that they arrived at an informed and objective conclusion based on credible material in their possession, that the proceeds of crime or documents related to money laundering are likely to be located at the premises sought to be searched. This procedural safeguard affords the principle of fairness and legality, ensuring that the exercise of power under section 17 of the PMLA is neither arbitrary nor speculative. A review of the recorded reason to believe, my lord may kindly note this, a review of the recorded reason to believe must show that the material available with the director is sufficient to support the conclusion reached. These conclusions must be based on reasonable evidence and logical reasoning, not merely a suspicion. For possession of proceeds of crime, the reason to believe must specifically show that the person being searched and control over and intend to use or manage the proceeds of crime. Simply holding the proceeds by chance or accident does not mean the person was involved in generating or hiding them as a part of money laundering. There must be a clear evidence of control or intent over the property to meet the requirements of the Prevention of Money Laundering Act. This ensures the law is applied fairly and prevents arbitrary actions. The learned ASG contends that where the criminal activity in the predicate offence pertains to illegal allotment of 14 sites by MODA during the tenure of the petitioner, the Lord may kindly mark this, during the tenure of the petitioner. My tenure commences only from June 2023. I am repeatedly submitting to your lordship, not prior to June 2023 at all. I was an utter stranger to MODA or even to the state, other than holding an office as a legislator. Beyond that, nothing more and nothing less. Petitioner as its commissioner, the said sites / properties as such satisfy the definition of proceeds of crime under section 2U of the PMLA. Therefore, where the allotted sites are the proceeds, The process of allotment presided over by the commissioner constitutes assisting a process of activity connected with the proceeds of crime and hence constitute a reasonable cause for the purpose of conduct of search and seizure under section 17 of the Act. The law clarifies that the petitioner at this stage of investigation is not an accused and that the impugned search was conducted on the basis of the reasonable belief that the petitioner as the former commissioner of Muda may be in possession of the proceeds of crime or any records related to money laundering. Then finally, my lord, kindly go to para 35, my lord, at page 39. The petitioner herein further challenges the repeated issuance of summons under section 50 of the PMLA, arguing that these summons are vague because they do not specify whether the petitioner is being treated as an accused or as a witness. This, according to the petitioner, violates the constitutional protection against self-incrimination under Article 20, subclause 3 of the
Supreme Court has
Constitution.
considered this issue. It does not amount to self-incrimination is what is said. Supreme Court has considered
It has,
this.
it has.
Yes.
Section 50 of the PMLA deals with powers of authorities regarding summons, production of documents, and to give evidence, etc. And the relevant portions thereof reads thus. His Lordship would quote, my lord, section 50. Then go to para 37. In the case of Vijay Madan Lal, the Honorable Supreme Court has clarified that the process under section 50 of the PMLA, which involves summoning a person whose presence is needed for gathering evidence or record, is part of an inquiry into the proceeds of crime and not an investigation to the prosecution under the Act. There is no doubt about this legal proposition. There is no formal accusation brought against the summoned individual at this stage to warrant invoking the constitutional guarantee under Article 23. In the case of Abhishek, etc., his Lordship would refer to any number of judgments on the point commencing from that paragraph till the end, my lord, that is paragraph 53, his Lordship would refer to it. Then, my lord, in paragraph 54, thus, in the light of circumstances of this case, where no prima facie case has been established showing that an offense has been committed under the PMLA and no incriminating material has been elicited at the time of search and seizure, the issuance of summons to the petitioner lacks legal authority. The petitioner cannot be compelled to appear and record the statements or produce documents, as such actions would unjustified, infringe upon the personal right to liberty. Then, my lord, in paragraph 57, kindly go to paragraph 57, this is what his Lordship would say. Finally, as against the submission of the learned ASG, that the instant petition suppresses the material facts of the petitioner and the scope of responsibilities incumbent upon him in relation to holding the office of the Commissioner of Muda in the past, it is to be observed that the petitioner is not an accused in the predicate offense, and that unless the petitioner were to be informed that the investigation conducted is in relation to the particular predicate offense under the impugned search and seizure, etc., my lord, his Lordship would quote it. And finally, my lord, his Lordship would give him the right or the liberty to launch or take necessary action against the officials of the ED. That your Lordship would get, my lord, at page 53, Roman 5. Liberty is reserved.
Doing the word.
But
Search and seizure.
Search and seizure was held to be illegal, that too by an unauthorized person, and the statement recorded is ordered to be quashed. In summons issued under section 50 also ordered to be quashed. And then, my lord, in Roman 5, his Lordship would say, liberty is reserved with the petitioner to initiate action under section 62 of the PMLA against the officer concerned before the appropriate forum, as whether the impugned search and seizure is vexatious or not is a matter of trial.
Question.
And the role, and if my lord permits me to take your Lordship, the basis, the foundational aspect is the private complaint. Well, in the private complaint, not even a remote reference has been made to the petition before your Lordship in this petition. Not even a remote reference. But certain incidents is said to have taken place between 1990 and prior to 2023. Nowhere a reference has been made to this petitioner. They could not have made any reference because I was not in the picture at all. Now, what is the purpose or object of they issuing me a notice under section 50?
Is it because you're the urban development minister today?
Looks to me,
Is that the reason?
obviously, my lord.
Allah, is that the reason for issuance of summons?
obvious, no, they must tell us why. But it is for them to say, what sin or wrong I have committed? How am I connected to this crime? Is there a single solitary allegation or a remote reference to me in the complaint which came to be filed and which is the basis of the foundational aspect of the issue in question? Crime number 12. That your lordship would get. ಇದು ಏನಾಗಿದೆ ಅಂದ್ರೆ kindly go to page 40 for a second, man.
Crime number 12 ಯಾವುದು?
ಇದೆ. I'm
ಅದು
sorry, 11. I'm sorry,
11.
11. I'm sorry.
ಅದಕ್ಕೆ ಬರ್ದು ನಮಗೆ
ಹೌದು.
ಗೊತ್ತಾಯ್ತು.
ಅಲ್ಲ 11 ನಲ್ಲಿ ಇದು ಏನಾಗುತ್ತೆ?
ಇನ್ಯಾವ್ದಾಗಿದೆ ಅಂತ.
ಹೌದೌದು. ಇದು ಏನಾಗುತ್ತೆ ಅಂದ್ರೆ kindly go to page 41.
ಹಾ. You have seen this judgment?
Not
Sandesh,
No, my lords, we have not seen it.
ನಮ್ಮ
Will it
ಯಾವ್ದು
camp-
ಕೂಡ ಹೇಳಿ.
Copy was given to us.
ಕೊಡಿ ವಾಪಸ್. Short order.
Please.
Yes, sir. ತಾವೇನು ಹೇಳ್ತೀರಿ?
ಇದರಲ್ಲಿ ಕ್ರೈಮ್ ನಂಬರ್ 11 ನಲ್ಲಿ ಇಟ್ ಕಮೆನ್ಸಸ್ FIR ಮೇಲೆ ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್ ಇಟ್ ಸಫಿಷಿಯಂಟ್ಲಿ ವೆಲ್. 4 ಜನನ್ನ ನೇಮ್ ಮಾಡಿರೋದು.
ಅದ್ರಲ್ಲಿ R9 to R12 ಇದ್ರು.
5ನೇವ್ರು ಏನ್ ಮಾಡ್ತಾರೆ ಅಂಡ್ ಅದರ್ಸ್, ಈ ಅದರ್ಸ್ ಇದೆಯಲ್ಲ ಈ ಟ್ರೆಂಡ್ಸ್ ಫ್ರಮ್ 1 to infinity ಯಾರನ್ನ ಈ ಆಕ್ಷನ್ ದಲ್ಲಿ ಬೇಕಾದ್ರೂ ಸೇರಿಸ್ಕೋಬಹುದು. ಇನ್ಫ್ಯಾಕ್ಟ್ ದಟ್ ಈಸ್ ನಾಟ್ ದಿ ಗ್ರೀವೆನ್ಸ್ ಆಫ್ ದಿ ಕಂಪ್ಲೇಂಟ್ ಇನ್ ದಿ ಕಂಪ್ಲೇಂಟ್ ಆನ್ ದಿ ಬೇಸ್ ಆಫ್ ದಿ ಕ್ರೈಮ್ ಕೇಮ್ ಟು ಬಿ ರಿಜಿಸ್ಟರ್ಡ್.
In fact, I think Pavana Dibbur, Supreme Court has said,
Okay.
unless there is an allegation of conspiracy, you can't draw someone.
Hopefully this goes against Vijay Madhanlal. We'll make a submissions on this, my lords, because the ratio has to be seen of Vijay Madhanlal. If there's going to be a discharge, this automatically goes. So we will see that, my lords. We will deal with this also.
That's what the ASG has relied on.
Out. Ultimately, my lords, which lays down the ratio. We will
According
go
to the learned ASG, this is what is
Yes,
now
my
the
lords.
thing. Yes, that's what he
What-
said.
What would be a ratio in a case, my lords? We will
That issue in
deal
the
with
case,
it.
I would say.
But I think I
Yes.
need not trouble your lordship by taking your lordship to section 3 and then 2U, what is proceeds of crime and all that.
That's all.
ನಂದು ಏನಾದ್ರು ಒಂದು ಸೆಂಬ್ಲೆನ್ಸ್ ಆಫ್ ಎ ಕೇಸ್ ಇದ್ರೆ ಹೇಳ್ಬಿಡ್ಲಿ ನೋಡೋಣ, ಅದಕ್ಕೆ ಉತ್ತರ ಕೊಡ್ತೀನಿ ನಾನು ಏನ್ ಮಾಡಿದೆ ಅಂತ. And the notice that is issued to me, my lord, requiring me to furnish the particulars as found in the annexure, my lord, it makes an inroad into my privacy, which is protected per Article 20 of the Constitution of India, would be by respectful submission. They can't. ಅದು ಯಾರ್ದು? ನಮ್ ಚಿಲ್ಡ್ರನ್, ಅಳಿಯ, ಮಗಳು, ಬ್ಯಾಂಕ್ ಅಕೌಂಟ್ ಕೊಡಿ,
ಅಲ್ಲದು ಫಾರ್ಮ್ಯಾಟ್ ಆ ತರ ಇದೆ ಏನು?
ಇದೆ, ಎಲ್ಲ ಇದೆ ಅದ್ರಲ್ಲಿ. ಅಟ್ಲೀಸ್ಟ್ ಹೋಗ್ಲಿ, ಕೊನೆ ಪಕ್ಷ ಅವರು ಈ ಫಾರ್ಮ್ಯಾಟ್ ಕೊಡದೆ ಬರೀ ಸಮನ್ಸ್ ಇಶ್ಯೂ ಮಾಡಿದ್ರೆ ಐ ಡೋಂಟ್ ನೋ ಹೌ ಥಿಂಗ್ಸ್ ವುಡ್ ಹ್ಯಾವ್ ಗಾನ್. ಕ್ವಶನ್ ಇಲ್ಲದೆ ಇದ್ದಿದ್ರೆ ಎಲ್ರದು ಇದೆ. ಯಾರ್ದು? ಸಿಸ್ಟರ್ಸ್, ಬ್ರದರ್ಸ್ ಇನ್ ಲಾ. ಯಾಕೆ? ಹೌ ಇಟ್ ಇಸ್ ರೆಲೆವೆಂಟ್ ಫಾರ್ ದಿ ಪರ್ಪಸ್ ಆಫ್ ದಿ ಪ್ರೆಡಿಕೇಟ್ ಅಫೆನ್ಸ್ ಆರ್ ಫಾರ್ ದಿ ಪರ್ಪಸ್ ಆಫ್ PCIR?
Details of property.
Your lordship would get that questionnaire at page 32. Passport, Aadhaar, family profile,
Last.
father.
Page 34.
Yes, my lord. Children, brothers, sisters, father-in-law. ಅದನ್ನೇ ಹೇಳಿದ್ದು. ಒಂದೇನ್ ಬಿಟ್ಟಿದ್ದಾರೆ
Last.
ಅಂದ್ರೆ ಗ್ರೇಟ್ ಗ್ರ್ಯಾಂಡ್ ಚಿಲ್ಡ್ರನ್.
ಅಲ್ಲ, serial number 10.
ಗ್ರೇಟ್ ಗ್ರ್ಯಾಂಡ್ ಚಿಲ್ಡ್ರನ್.
10.
ಹೌದು
10.
ಹೌದೌದು. ಕೋ ಬ್ರದರ್ ಹೇಳಿದ್ನಲ್ಲ, ಕೋ ಬ್ರದರ್ಸ್ ಇಲ್ಲ, ಚಿಲ್ಡ್ರನ್, ಗ್ರ್ಯಾಂಡ್ ಚಿಲ್ಡ್ರನ್
Grand children ಇದೆ?
ಇಲ್ವಾ?
ಒಂದಿಷ್ಟು
ಇಲ್ಲ ಅದಿಲ್ಲ. ಮತ್ತೆ ಈಗ ನೀವು ಹೇಳಿದ್ರೆ ಅದು ಬಂದ್ಬಿಡುತ್ತೆ.
ಅಲ್ಲ, ಯಾತಕ್ಕಿಲ್ಲ ಅಂತಂದ್ರೆ ನನಗೆ ಮೊಮ್ಮಕ್ಳಿಲ್ಲ,
ಓ, ನಿಮಗಿಲ್ಲ ಅಂತ.
ನನಗಿಲ್ಲ. ಅದಕ್ಕೋಸ್ಕರ ಪ್ರಾಬ್ಲಿ
ಅದು
ಈಗ ಮೊನ್ನೆ 7th ಮದುವೆ ಆಯ್ತು, ಗ್ರ್ಯಾಂಡ್ ಚಿಲ್ಡ್ರನ್ ಸೇರಿಸ್ಬಿಡ್ತಾ ಇದ್ರೆ ಏನೋ ಅಂತ ಅಷ್ಟೇ. They would have done it. And ಜೊತೆಗೆ kindly go to page 36, minute 36. Ancestral property, self-acquired property. Okay? Page 36. ಲಾಕರ್ಸ್, ನನ್ನ ಲಾಕರ್ ಯಾವ ಬ್ಯಾಂಕಲ್ಲಿ ಇದೆ ಅಂತ, ನನ್ನ ವೆಹಿಕಲ್ಸ್. Am I answerable to these people? Certainly I am answerable, not to these people. to the Central Revenue Agency, if at all I am required to answer. I will answer them. Not to attenuate ED. ಇವ್ರು ಯಾರು ನಾನು ಕೇಳೋದಕ್ಕೆ? ನಿನ್ ವೆಹಿಕಲ್ ಯಾವ್ದಿದೆ, ಲಾಕರ್ ಎಲ್ಲಿದೆ, ancestral ಪ್ರಾಪರ್ಟೀಸ್ ಯಾವುದು, ಸೆಲ್ಫ್ ಅಕ್ವಿಸಿಷನ್ಸ್ ಯಾವುದು, ಬ್ಯಾಂಕ್ ಡೀಟೇಲ್ಸ್.
ಲ್ಯಾಂಗ್ವೇಜಸ್ ನೋನ್ ಯಾಕೆ ಕಮ್ಯುನಿಕೇಟ್ ಮಾಡಕ್ಕೆ? ಎಸ್, ರೀಡ್, ರೈಟ್, ಸ್ಪೀಕ್. ಎಸ್,
ಅಲ್ಲ ಇದು as my lord has seen it, these children, brothers, sisters, father-in-law, brother-in-law, sister-in-law, co-brothers, and ಜೊತೆಗೆ ಲಾಸ್ಟ್ ಅಲ್ಲಿ ನಂಬರ್ 3 associates. ಅರೆ
ಎಸ್ ಸರ್, ಅಷ್ಟೇ.
this notice has got to go. Notice has got to go.
Let the AG sir objections ಹಾಕ್ತೀರಾ?
Alla, not what I thought was, my objections are almost ready. Maybe I'll file it tomorrow or day after. And let my learned friend, Mr. Chowta, conclude his submissions today. I mean, if he can.
Filing their objections, my lords. Fail to understand.
No, without objections.
They're not going to file objections. They're not
Objections
filing
ಹಾಕ್ಬೇಕು.
objections.
You want to submit, you submit, no problem.
Please.
Alla, but fact of the matter is that I will be filing my pleadings.
Yes, no, I will be permitted to file your objections also.
Choice is
Without
of my
objections,
learned
we will
friend
not
Mr.
close
Chowta
it.
either to argue or not to argue. I mean, I am going to
Yes.
file it maybe within a day or two. And then if your lordship could have it on Thursday.
In the same grounds, Chowta sir.
I have
Say-
additional grounds.
ಅಲ್ಲ,
Because I was an accused in the predicate offense
ಹ್ಮ್,
and now I receive a summons.
ಹ್ಮ್,
My lords, in criminal petition 1132 of 2025,
ಹ್ಮ್,
both my lords, Mr. Vikram and me are appearing in that matter, my lords.
for one person.
Yes.
Why?
Sandesh will make some, problem is.
Because of the eye. ಅದು ಆಗ್ಲೇ ಮಾಡ್ಬೋದು ಆಯ್ತು. ಅಲ್ಲ ಅಲ್ಲಿಗೆ
My lords, I'll broadly point out, my lords, the three contentions that I'm going to be canvassing. my lords.
ಎಸ್,
My lords, what we are seeking is not just the quashment of the summons which is issued under 50, but what our prayer is for quashment of the entire proceedings which the ED has initiated. I will substantiate as to why we have made that prayer, my lord.
your prayer is that?
Yes, my lords, my prayer is that. Now, my lords, 3 points, my lords, main points that I'm contending on. My lords, as on the date of initiation of the ECIR proceedings or proceedings under the PMLA, there exists no proceeds of crime. This will be my first contention. As I'll point out from the sequence of what has happened, there exists no proceeds of crime. There can't be an initiation of proceedings under the PMLA. Secondly, my lords, would it be permissible to permit an investigation which is at its infant stage when the ECIR was registered? Would it be permissible to permit an inquiry under the PMLA happening parallel to an investigation to the predicate offense? This would be point number 2, my lords. As I will point out, my lords, generally, my lords, when we say the predicate offense should establish that there is a proceeds of crime from a schedule offense. Only then, my lords, the cause of action arises under the PMLA Act. Here, my lords, in my respectful submission, when a FIR is registered, within 4 days, if an ECIR is going to be registered and they put it on writing that they are inquiring into the very same allegation which is being investigated in the predicate offense, would it be permissible? This would be point number 2, my lords. And the third point, my lords, in view of the quashment of the proceedings, insofar as the then commissioner of MUDA, against whom the allegation was, it is he who has allotted this 14 sites, then, my lords, what would be the effect of me being the recipient of that 14 sites?
beneficiary.
Beneficiary, me being the beneficiary, when, my lords, the proceedings against the person who has allotted has been quashed, what would be the effect therein? This would be the third aspect of it. These three contentions, my lords, are my broad contentions. Now, incidentally, my lords, when touching upon these three contentions, my lords, we will also be covering with what amounts to a proceed to crime. What's a proceed of crime? I will be touching upon that, my lords. And when does ED get jurisdiction, my lords? One of the aspects raised is on the jurisdictional aspect of when they get jurisdiction to even register an ECIR, my lords. Then, my lords, what would be the effect of section 107 of the BNSS to an PMLA proceeding? Now, this, my lords, assumes some importance because 107, my lords, under the BNSS was not there in the corresponding CRPC, my lords. Now, 107 specifically deals with proceeds of the crime. It gives a power of attachment. It gives the power to forfeit. Now, with 107 of BNSS being introduced, what would happen to the proceedings under PMLA? Whether, my lords, when the investigating officer to a predicate offense senses there is a proceeds to crime, he can attach it. He places it before the court. The court later has the power to forfeit it. Then, my lords, under section 5 to 8, attachment under PMLA, what would be the interplay between these two provisions? Something, my lords, which we have not had any judgment on.
Yes.
It is going to be for the first time. Now, my lords, to substantiate this, the third aspect which I just pointed out, my lords, the effect of the order passed by the coordinate bench in quashing the proceedings, what would be its effect insofar as the present summons is concerned? My lords was pleased to see the order, my lords. If for a minute, my lord sees paragraph 8 of that order, the 4 points that was considered by the coordinate bench, my lords, it said, page 13, the issues, my lords may notice the issues. The first issue, whether the authorization issued to conduct the impugned search and seizure at the residence of the petitioner on 28/10 and 29/10 and the consequent statement recorded under section 17 suffers from lack of jurisdiction. My lords, the point which we made out here was that, my lords, under section 17, the authorization can be given only by the director and no one else other than the director, my lords. But however, the court would hold, even if it is a case of subdelegation, it is all right. So this issue is answered against us. The first issue, my lords. Second issue, whether the said impugned search and seizure and statement recorded is bad in law for lack of requisite reasons to believe under section 17(1) and therefore an abuse of process of law, court holds in our favor, my lords. It is these reasons to believe, my lords, as we see in the act, we get it in about 8 places, my lords, in this act, and that becomes the absolute basis to have proceedings under it, my lords. Everywhere we get it, except we see in section 50, my lords, there is no usage of the word reasons to believe. Otherwise, in all other sections, we get the reasons to believe. And Vijay Badan Lal, they say, my lords, it's very different to see reasons to believe from reasons to suspect. That's the differentiation, my lord. So you must have something very concrete if you want to initiate proceedings under the PMLA Act. The third aspect, my lords, whether the impugned summons notice issued under 50 and various statements recorded therein be sustainable under law. Court holds it is not sustainable in this case, in our favor. Fourth one, my lords, whether in the course of its administration and execution of PMLA, the attachment of property under section 5 of the Act must mandatorily precede the conduct of search and seizure under section 17. My lords, this is for this contention, my lords. What we had pointed out is the whole Act PMLA is for protection of money laundering. Now, if it is an act for protection of money laundering, the first step to be taken under the Act, my lords, in our respectful submission, was that as soon as you sense there's a proceeds of crime, you will start with section 5 of having an attachment of it. After 5, my lords, when the conferment happens in 8, my lords, 8 says, when you are confirming it, you issue a notice to the person from whom this proceeds of crime has been attached. As a reply to that, when you get it, and you assess that there is a crime created under section 3, that is where the process of this criminal action begins. Because PMLA has both actions to it, my lords. One is going to be attachment, other is going to be the offense under 3 and 2.
You mean to say the drill should be in this seriatim like this?
My lords, is what we had contended. But court said there may be instances where even without attachment, they may proceed. So this point number 4, my lords, here, court said instances are there where it, so it need not be that in under 5 you have done an attachment, you may start the process otherwise. This is how it has been held, my lords. And after what the court has discussed, my lords, in that case, what took place was, even before issuance of summons under 50, they first came to the house, did search and seizure. And in the search and seizure, they did not get anything. So what they would do is they would take my phone, my lords, and from my phone, they showed that as seizure.
What?
My phone,
Huh.
they seize my phone, that is shown as a seizure under section 17. My lords, what should be seized under 17 would be proceeds of crime. But here, since they didn't get anything from the house, my lords,
ಫೋನ್ ತಗೊಂಡಿದ್ದೀರಾ?
phone,
ಅದೇ that is what?
ಅದನ್ನ duplication ಮಾಡ್ಕೊಂಡು, that is what they had retained.
ಯಾವ್ದು ಐಫೋನ್?
Yeah,
ಮತ್ತೆ
phone ಅಂತ
ಅದಕ್ಕೆ ಬರೋದು ಮತ್ತೆ.
My lord, phone is a record, my lord.
Anyway, this is what
Section
happened.
2 and phone is a record.
Phone is not
So we have seized
seized.
the record.
No, phone is not seized as a proceeds of crime. Phone
It
is
is seized as a record.
to see whether there are any records of proceeds of
So, my
crime.
lords, on a
Exactly.
suspicion,
And
if
this
you're going to
argument
be
was
doing,
not at all raised in that court.
on a suspicion, if you're going to be doing a section 17 search and seizure, my lords, then the
No, you
entire
submit
basis-
on that.
Yes,
I don't agree with your drill, seriatim drill at all. It is not that an attachment order should be passed, summons should be issued. It's not that the procedural drill is not that way. It can be done. It's a flexible thing, that's all right.
Issued under 50 and later there's an attachment. it is
No,
fine.
there is no problem at all.
So this is where the court would not agree with the submissions, but the two aspects which the court agreed was this entire action taken by them is absolutely unfounded. Prima facie, there is no case made out under the PMLA Act. My lords, we saw paragraphs 25 and 26, which was read out, my lords. Very clearly they would hold, my lords. And then paragraph 54, my lords, 25, 26, my lords has it at page 35. My lords would have seen that portion.
ಈಗ senior ಓದಿದ್ರಲ್ಲ.
How 25, 26, 54 ಅಲ್ಲಿ. Please notice 54.
ಹಾ.
No prima facie case to establish showing an offense that has been committed under the PMLA Act. Now, we all stand on the same footing insofar as the proceedings are concerned. And the court had the benefit, my lords, of seeing through the records. And after seeing the records, court finds this was not a fit case for you to have initiated this process at all. Now, my lords, with this, insofar as the first and the second contention is concerned, my lords, I have prepared an index with synopsis, my lords.
ಅವ್ರು ಕೊಟ್ಟಿದ್ದೀರಾ? ಕಾಮತ್ ಸರ್, ಕಾಮತ್ ಸರ್ ಕೊಟ್ಟಿದ್ದೀರಾ? ಏಜ್ ಅವ್ರು.
We will give it now, my lords. We're giving the synopsis now.
Even a soft copy can be sent.
ಹಾ.
I'll send a soft copy. My lords, we have gone a little bit in depth on PMLA, my lords, right from its
Which will you
origin,
not
my
go
lords,
in depth?
times, right from its origin to see, my lords, what exactly do we mean by proceeds of crime and what is the object of this PMLA Act? Now, my lords, the very object of PMLA Act is to prevent laundering, my lords. Now, what is laundering, my lords? When we get gains out of a crime, we try to layer it and then bring it back into circulation as a legitimate income, it becomes laundering. I will point that out, my lords. My lords, please notice the index page itself, my lords, how under 14 categories for a minute, my lords.
14 categories. Yes.
My lords, you notice the synopsis and list of dates, which is relevant for this case. And then, my lords, the history and evolution of the PMLA Act, it started off with the treaties and authorizations, my lords. My lords, what they felt initially was it all started because of the NDPS Act, my lords. The NDPS Act, the money which was got, what they called as dirty money, my lords, that was sought to be put into the system, circulated, and then portrayed as legitimate money. That was the object for which, my lords, they felt we need an act that will prevent this laundering of money. That was the object behind it, my lords. So that is the history. Then, my lords, the parliamentary debates. Now, the debates also, my lords, very clearly established, my lords, it was only for the purpose of preventing laundering that the act was required. And they go to the extent of saying, my lords, in the debates, my lords, if there is not going to be
Yes.
if there's not going to be a charge sheet to the predicate offense, you ought not to be initiating action under the PMLA. This is how the entire
That's in the debate.
debates, my lord, in the debates. Then, my lords, what we have pointed out as number 4 is essential ingredients to constitute process of crime, the definition of money laundering and process of money laundering, scope of section 3 of PMLA Act, and my lords, one very important aspect, my lords, would be enjoyment of, yes, my lords. That's the exact definition of money laundering.
Hmm.
Please notice, my lords, what we see there is first is dirty money, my lords. Kindly notice that diagram, my lords. I'm sorry, I just, since my lords is seeing that diagram. My lords, kindly notice this collection of dirty money which we have on the left-hand side. It is, my lords, out of the schedule offenses. Now, from schedule offenses, whatever that you gain is shown to be as dirty money, my lords. Now, then there's a placement of the dirty money. After the placement, my lords, this dirty money integrated into the financial system, and then there's layering done to it. It gets integrated, and then it is tried to be portrayed as legitimate income. This is the whole object, my lords, of this money laundering.
No, your seventh point.
Yes, my lord. 7, the accused must be in enjoyment. My lords, this according to me is one of the most crucial aspects, my lords, for a case of PMLA. Now, my lords, given a situation, I'm just going to show certain examples also, my lords. Given a situation, a case of cheating, and my lords, the accused has been able to get a gain of 1 crore. Now, my lords, if that 1 crore, he returns back to the person from whom he has cheated, it still amounts to an offense under 420 or breach of trust. It will not amount to an offense under PMLA Act because, my lords, proceeds of crime.
Not in enjoyment of the.
Not
crime.
in enjoyment of it. That is the most important aspect under section 3, my lords. Section 3, clause 2 deals with that word enjoyment. Now, in our case, I will point out, my lords, as soon as the orders were passed, the 14 sites were returned back. After the sites get returned back on the same day, this ECIR gets registered. When the sites are no longer with me, but with the authorities concerned. Now, if there's no enjoyment of a proceeds of crime, my lords, this particular
Crime will not vanish.
crime may predicate will not vanish. Predicate will not vanish, my lords. I have to face the predicate offense. But if it is going to be so far as PMLA, my lords, then if the PMLA has not been initiated before I have returned it back to the lawful authorities, then, my lords, PMLA won't lie. That's it. That's the reason, my lords, we have used the word enjoyment. I will show from the clause itself, my lords, how the word enjoyment is.
Any interpretation? Any judicial interpretation of this?
On enjoyment, my lords. My lords, we have used some judgments where all these words of possession and proceeds of the crime, what you need to do with it, we have done it, my lords. In the compilation, it is there. I will point out as we go on, my lords. My lords, 8th aspect of it is factors to be fulfilled for the enforcement direct to assume jurisdiction. About 12 factors, my lords, I have pointed out there. 9, ED must necessarily satisfy itself that proceeds of crime have been projected as untainted property. My lords, we get that in the debates, but this has got slightly diluted, my lords, this particular portion of it. My lords, what were the 3 essential ingredients was, one is you should have had proceeds of crime from a schedule offense. Second is that you should have laundered the proceeds of crime. And the third, my lords, which we have written here, you are using this untainted property as legitimate property. This, my lords, has been diluted. I may point out from Vijay Madhalal's case, my lords, and subsequently V. Senthil's case, my lords. V. Balaji's case.
Senthil Balaji.
Yes, my lords. Why Balaji? But why Balaji is the same as Senthil Balaji, my lords. But Senthil Balaji was dealing with bail. But really, when it came to the quashment, my lords, it was shown as Y Balaji. But it's the same minister, my lords, in both. Tamil Nadu. So, my lords, then 10th one, a parallel investigation of predicate offense by...
Quashment was dismissed, not quashed.
No, it was not quashed. It was not quashed. No.
No, bail could, bail.
One judgment is on the bail. Second one was on so far as the quashment is concerned.
Quashment is dismissed.
My lords, that was a case, my lords. We had 4 FIRs. 3 FIRs, charge sheets were filed. 4th FIR, 1 day before the charge sheet was filed, the ECIR was registered. And that ECIR was registered 6 years after the first charge sheet. So then the contentions were taken. You should have waited for everything to be over. They said nothing doing. We won't wait till everything is over. 3 FIRs have been charge sheet. Fourth one day before the ECI is registered. Nothing wrong in registering the ECI. And there they were able to show proceeds of the crime. So, my
So
lords,
we'll come back to enjoyment.
my lords, the 10th, which we showed, parallel investigation. 11th, my lords, effect of the proceedings under PMLA is vis-a-vis BNSS 107, my lords. I will point that out. 12, allotment of site by itself does not constitute an offense. That even my lords coordinate bench has agreed with that, my lords. And some illustration, classical examples of money laundering. My lords, it's in this fashion that the whole thing has been done. But my lords, now that Mr. Kamath says that he will
Objections
file,
are
yes, my lords, let him file his objections.
Yes,
And
yes, sir.
one request could we make, my lords, we have filed an application where additional grounds have been taken, my lords. If that application.
What additional grounds?
My lords, same, what has been there, if the application and the.
Grounds ಅಷ್ಟೇ ಅಲ್ವಾ?
Grounds, my lords.
Will be heard along with the main matter. It's all right.
We have filed even that.
Yes,
application
yes, sir. Next Monday?
My lord, that would be,
No, but you said you need 2 days.
yes, please.
24th, 24th, if it's possible. I
Why?
know Mr. Nagesh and Sandesh are here, but if it's possible, 24th, other than next Monday. The reason is 17th, my lords, the elections are there in Bangalore, so.
What election?
My lords,
ಅದು postpone ಆಯ್ತಲ್ಲ, Supreme Court order.
Whether this Friday, my lord, whether
13th, this Friday, 14th Friday?
14th, my lord, 14th.
14th, I am here.
ಇಲ್ಲೇ ಇದ್ಬಿಡಿ ಆಗ.
14th ನಾನಿದ್ದೀನಿ, ಅದಕ್ಕೆ.
13th, I think you have 10 cases here. Yes, sir. Age, sir.
My lord. Lord, 13th, Lord, I would like to
13th.
come physically on 14th.
That's all right.
14th, if the lordship would permit, I would come physically.
2 matters, I'll spill it over to 14th. ನಿಮ್ದು. ನನ್ಗೆ any time. No, ನಾ ಇಲ್ಲೇ ಇರ್ತೀನಿ, no problem. Any time. Gaman sir.
No.
Senior is saying 20th. Vikram sir, 20th election ಇದೆ ಅಂದ್ರೆ?
ಇಲ್ಲ, 16th, hopefully it will be over, barring any further orders.
ಇನ್ನೇನ್ further order?
ಇನ್ನೊಂದು petition ಹೋಗಿದೆ, ಮತ್ತೆ.
Lord,
It is part of the high power committee. my
His
lords.
lordship is there.
So that time.
20th, my lord, for my learned friend Mr. Chowta to continue, my lord.
ಒಂದು
Objections?
All objections now, ಇನ್ನೊಂದು 3 days.
3 days he will file his objections.
I will file the objection within 3 days, so he'll have sufficient time.
20th, we'll fix it at 20th.
20.
That is
20th.
Thursday.
That is Thursday.
Heard the learned senior, lim separate ಅಷ್ಟೇ.
My lord, registry may be directed to show
It is
my
not
name.
linked at all. It is not linked. It's in seriatim ಅಷ್ಟೇ. ಜೊತೆ ಇರ್ಲಿ ಬಿಡಿ. Yes.
My lord, registry may be directed to show my name, my lord, Madhukar Deshpande's name.
ಯಾಕೆ ತೋರಿಸಿಲ್ವಾ?
Our name is not shown, my lord, in both the cases.
Registry to show the name, print the name of Madhukar Deshpande appearing for the enforcement directorate, ಇವೆರಡರಲ್ಲೂ, both the matters. 11/29 ಬರ್ಕೊಳ್ಳಿ. Heard the learned senior counsel C.V. Nagesh appearing for the petitioner. The learned senior counsel has concluded his submissions. The learned additional Solicitor General of India representing the enforcement directorate seeks week's time, Kamath sir?
Week's time.
A week's time to file his statement of objections. A week's time is granted. List the matter on 20th. At the 20th, it is Bangalore matters day only, so we'll keep it at 10:30. 20th for further hearing. 2:30, yes. ಆಯ್ತು 2:30ಗೆ ತಗೊಂಡು ಆಮೇಲೆ ಇದರಲ್ಲಿ ಸೆಕೆಂಡ್ ಅಲ್ಲಿ the learned counsel Sandesh Chowta, senior counsel Sandesh Chowta representing the petitioner has also completed his preliminary submissions and would submit after the objections are gone through. The learned ASJI seeks a week's time to file a statement of objections in the case at hand as well. Therefore, list this matter again on 20th in the same stage for the hearing. Interim orders subsisting in both these cases will continue till the next date of hearing.
Very good.
Yes.
Deeply obliged.
Yes.
Grateful.
14 points.
Serial number 3. Praveen Kumar. Serial number 3.
For petitioner, my lords.
Serial number?
For petitioner, my lords.
Yes, sir. 1 minute.
Await service of respondent
Post
number 2.
immediately after service of notice upon the second respondent. Yes. For the hearing.
Plus interim order.
Intermodal will continue. Yes.
Serial number 4. Sunil Kumar S. Son of Marti.
Yeah,
This matter, senior.
Yes. Counsel.
Paper books.
Hello, brother. ಎಲ್ಲಿದ್ದೀರಿ ಇಲ್ಲಿ ಯಾರ ಜೊತೆಗಿರ್ಬೇಕಲ್ಲ ಅಂತ ಅಷ್ಟೇ.
I am for appeal.
You are there. Come. Where do you leave senior and go? Yes. Come. ನೀವೆಲ್ಲ ಅವ್ರು ಬರ್ತಾರೆ ಅವ್ರ ಜೊತೆಗಿತ್ತು. Yes, sir. ಏನಿದು? Oh, this is mining matters.
ಪೇಪರ್ ಬುಕ್ಸ್
ಆಗಿಲ್ವಾ?
ರೆಕಾರ್ಡ್ಸ್ ಬಂದಿಲ್ಲ.
ರೆಕಾರ್ಡ್ಸ್ ಬಂದಿಲ್ವಾ?
ಇಲ್ಲ.
SCR called awaited. ಇದು 20th ಹಾಕಿರ್ತೀನಿ ಹಾಗಾದ್ರೆ.
Probably one difficulty may be there. He is not the sole accused.
Yes, he is not the sole accused.
Then ಒಬ್ಬನ accused ನ segregate ಮಾಡಿ ಜಡ್ಜ್ಮೆಂಟ್ ಅಂತ ತೀರ್ಮಾನ ಮಾಡಕ್ಕಾಗಲ್ಲ.
ಮಾಡ್ಬೋದಾ?
ಅಲ್ಲ ಮಾಡೋಕ್ಕಾಗತ್ತಾ?
ಇಲ್ಲ,
ಆಗಲ್ಲ. ಆದ್ರಿಂದ ಇದು ಹೇರ್ ಮಾಡಕ್ಕಾಗಲ್ಲ.
ಹಂಗಲ್ಲ, ಎಲ್ಲರ all the petitions are not here.
ಇಲ್ಲ.
Numbers ಎಲ್ಲ ಕೊಡ್ಬೇಕು.
ಓನ್ಲಿ ನಮ್ಮದು ಮಾತ್ರ ಹೇಗಂತ ಹಾಕೊಡ್ರಿ.
How many accused are there in this?
ನೋಡಿ, each one of the cases there are half a dozen accused. And each one of them have filed separate appeals.
Appeal numbers ಕೊಟ್ರೆ we'll tag them all together.
ಕೊಟ್.
Yes.
I leave it with the registrar.
Look at record.
Let the
Sunil Kumar.
records
Yes,
and
yes, my lords.
registry has got to keep the paper books.
That I will direct. But ಇದು let the trial court records ಬರ್ಬೇಕಲ್ಲ.
ಬರ್ಬೇಕು. ಆಮೇಲೆ ಅವ್ರ
ಆಮೇಲೆ ಬರ್ಬೇಕಾಗಲ್ಲ. Yes, the Sunil Kumar, give all those
Yes,
numbers.
Yes, my lords, I'll provide.
I am
the-
representing him, my lord.
Rahul,
Yes, my lords.
Rahul, ಯಾವ್ಯಾವ ಮ್ಯಾಟರ್ ಪೆಂಡಿಂಗ್ ಇದೆ ಇದೆಲ್ಲ ಇದಕ್ಕೆ ಸಂಬಂಧಪಟ್ಟಿದ್ದು ಕೊಡಿ.
Yes, my lords, I'll assist the court officer.
Yes. So and so. List the matter on 20th ಹಾಕಿರ್ತೀನಿ ನೋಡೋಣ. Let the trial court record.
Please. No problem.
The, yes.
May I mention, my lords?
Yes, sir.
Lordship, my lords, my lordship may have it after 2 weeks, my lords, because my lords, it's voluminous paper books.
ಹಾಗಾದ್ರೆ we'll post it directly on 7th March. List the matter on 7th March along with all connected matters arising out of the same proceedings. The trial court records be secured. The session court records be secured by then. By if needed by way of telephonic instructions. Amal paper book. Yes. Interim order subsisting. ಇದೆಯಲ್ಲ ಎಲ್ಲ. Bail suspended. Appeal ತಾನೆ.
Suspension of sentence.
Yes, suspend ಆಗಿದೆಯಲ್ಲ.
ಆಗಿದೆ.
ಆಗಿದೆ.
Conviction is also
conviction
stayed.
stay ಮಾಡಿದೆ.
Conviction is also stayed.
Yes.
Deeply.
ಏನಾಯ್ತು? ಏನ್ ಕನ್ಫ್ಯೂಷನ್? ವಿಶಾಲ್ದಾಯ್ತಲ್ಲ? ಅವ್ರದ್ದಾಯ್ತಾ?